Welcome back to the county seat. This is the part of the show in our new format where we have a discussion with what we consider to be revered experts on our topic. Our topic today, of course, being RS-2477 roads and the impact they've had on Utah. Joining us for our conversation is a commissioner who is from what I call the ground zero county, Kane County, where most of the controversy started well over a decade ago. And Jim Matson is a commissioner in Kane County. We also had David Halverson, who is legal counsel for the Public Lands Policy Coordinating Office, or PLPCO, as it's known in the in circles. David, thank you for joining us.
Happy to be here.
So, has the process of resolving the RS2, from the time that Jim's predecessor pulled up the stakes and put down county road signs, have we made any progress at being really close or having a system in place where we think we can resolve the issue?
I think as we start to look at this issue in over a little more time, and it's, it started out as more or less a administrative, kind of a technical issue. It devolved into a legal challenge as such, so we're seeing our way through that process to the point that where we can try to figure out how to maintain access. If you look at a county like ourselves, which is just under 4,700 square miles, access is a big question and a real big need that we have as we go through all of that. So do we end up becoming a preservation-based county and area, or do we actually have it set up so that our people and our friends and visitors that come to visit us can actually enjoy the total area that's out there? And as long as there is a movement underfoot, to limit our ability to travel to those areas, we're going to conduct our portion of this in terms of the lawsuit itself.
So, like the video would say, it's only a name, RS-2477 versus Title V, who really cares? But to put that in real context, how much of your transportation system literally has been affected by this?
Oh, I haven't really looked at it from the standpoint of numbers, but it's well in excess of 80%, so it's a big ticket item for us.
And has most of this happened since the monument was declared?
It started out before, and then it became a monument, and then now we've got this going on and being continued to this extent that we have today. Whether there's the question about the legal steps that I'm sure is going to be talked about, the bellwether roads, or how do we deal with this thing, but the size, the number, the mileage, it's a big question. So we need to kind of make sure that we understand how's the best way to get at a resolution of that. And we incidentally, we think we're right.
Well, that's good. You should think you're right if you're going into a challenge. Just to kind of bring this into context, because most of the people watching this program right now do not live in Kane County. They live up here on the Wasatch Front, and they're thinking, well, what do I care about some dirt road to a windmill or a well that some rancher uses twice a year? Can you guys give me some examples of RS-2477 roads that people from the Wasatch Front are more likely to understand are RS-2477 and could be closed under a Title V category?
Well, I think the Hole in the Rock Road in Kane County is a prime example. Perhaps you can talk about that more specifically.
But given its location and how it accesses the eastern side of the county and what its impacts are as far as getting down to the national park and that portion of the Hole in the Rock itself, it provides that means by which we can enjoy that eastern edge of our county, as it also impacts Garfield County. So this isn't just a Kane County issue as such, it's very much a big part of that.
And it's not like roads like the Hole in the Rock Road are a great one that tourists from all over the state come to use. Mm-hmm. It's a historical site that people like to visit, and that's one of our roads. We do have roads that are used less often, but we have roads that are used every day, or roads that are very commonly used by people all over, by tourists, by ranchers, by farmers. There are roads that there's a town in Twila County that I've been to where the only way to get there is on an RS-2477 road. Yep. And it's a good road, but if you close that road, the people that lived in that town couldn't get in and out. And so it's not just roads that are out in the middle of nowhere that nobody uses or only gets very sporadic use, but it's also roads that are used frequently and that are vital to the people that live locally, but also people that live here in the Wasatch Front that like to go there to recreate and see the land.
Well, prior to Mayor Workman, I believe Salt Lake County even had some RS-2477 roads that were abandoned during her administration. Is that not correct?
I'm not sure. I know Utah County does. Utah County has RS-2477 roads, so it's not just in southern Utah or in the rural counties. We have, on our litigation that we are pursuing now, we have 22 counties and about 12,000 roads across the state. And so it's really not just in Kane County or just in the counties in southern Utah, but it's all over the state. That this is really a prime concern for the counties to make sure that they preserve access. A lot of these counties have such a high percentage of BLM land that if we don't have the roads, they can't access that land. There's not much good to having the land if you can't get to it, if you can't use it.
So somebody would be listening to this and they go, "Oh, get off it." I mean, what's the likelihood that a current Title V road that's been historically used is going to get closed? Is that even a possibility, or are we tilting at windmills here and it's not really an issue?
Well, there have been roads that have closed. That's definitely the case in both BLM and in the Forest Service. There is a steady push to close roads in certain areas. It's not that we're worried that they're going to close all 12,000 roads, and there are certain roads that are not probably top priority for the BLM to close, but there is that risk. And the state and the counties want to be proactive. We have to show that the roads were used prior to 1976. So the longer we wait, the harder it is to gather that testimony and to gather that evidence. So if we wait another 10 years and then BLM decides they want to close that road, we're making it so much harder on ourselves to be able to collect that testimony.
So as a legal counsel, do you find it difficult that for you to prove up road use 10 years prior, that you can go and look at a 1966 U.S. Geological Survey map, you can look at a Rand McNally road atlas and see a route published on a map, and that is not enough evidence to prove that the road was in use prior to 1970? It's even further for the Forest Service, isn't it?
Yes. And most of our RS-2477 claimed roads are on the BLM because the Forest Service were set aside even earlier, and so those are even harder to get through this litigation. But it is, the maps are not always sufficient, and so we do need that testimony as well. That's why we go out and we do probably about 150 depositions a year in different counties across the state, trying to collect testimony of those people that were there prior to 1976 that were using the roads, and really for any public use. They could have been ranchers or farmers, they could be out hunting, they could just be recreating, just driving around, seeing the sights.
It boggles my mind, though, that if the government acknowledged it on a map, that wouldn't be sufficient proof to just say, well, it's on the, I mean, if I were a judge looking at it and I were trying to solve a spat between somebody saying, that's not a road that you get a claim to because it wasn't prior to 1966, and I'm looking at a 1952 map and I go, well, it's here, and it's on your map, Mr. Government, so why logically that seems to me that would be evidence.
Yeah, I've always been surprised by how loath the federal government is to admit any of these roads. There are certainly roads that are in dispute that we should have some litigation over or should have a court to help us. But there are RS-2477 roads that are paved roads, that are highway roads, that are used almost every day, and the government still won't admit even those roads. And so I have that same kind of frustration sometimes of there should be some roads that reasonable minds should be able to sit down and say, nobody disputes that this is a road that the public has been using for decades. It's been on maps from '66. It's been on, the pioneers used it in Kane County when they first got there.
So do you think the federal government is just at a point where they're thinking, well, I don't want to give up the control just in case someday I want to do something different. I want to boot out Best Friends Animal Sanctuary, so I don't want them to have access to their kitty kennels or whatever they call them up there, because that is an RS-2477 road up to those back.
Up Angel Canyon, you bet. Yeah. So we have other roads like that same situation that have been around and in use for however long, So what is the issue? Is it title? Is it access? What's the agenda? What's the federal government trying to accomplish here? And it's interesting to me whenever I think about this is that, you know, way back in the 1800s there, the federal government sold lands in order to fund federal government operations. So if you bought a piece of real estate back in the backcountry somewhere, you had to figure out how to guarantee access, and oftentimes these are the very same roads that the federal government is trying to keep us from having title to. So it just does not add up in a logical way.
And up until 1976, the federal government was trying to promote building and using the road. That's why RS 2477 was passed. That's why it was on the books for 100 years, because they wanted people to be able to build roads, to be able to have access to the federal lands. It's not until 76 that we see the shift in the federal government's position of wanting to hold on and being much more reticent to allow access and to grant title.
That doesn't seem like a shift. That seems like a major seismic event, because it almost overnight in September of 76, it's almost like it took a 180-degree turn. But it took a little while for it to manifest. It wasn't the first real challenge on this when Garfield County paved the Burr Trail Road down through the Dry Canyon.
Yes, it goes back to that period of time, you know, in the early 90s, you know, over that whole issue, and so it raised this whole specter of this thing. So, you know, to me personally, I think it's a bad faith effort on behalf of the federal government to deny access to areas that have been accessed ever since the 1900s.
Well, bad faith effort. I just heard that in a court case just recently, but I won't go there. So the question is, what makes us have to litigate this? I mean, if you had a change in administration like we currently have, and they went, okay, well, I guess you're right. Couldn't they just stipulate this and it would be over? Couldn't the BLM just say, we stipulate and we'll sign a record of decision saying that we were recognizing the county's right-of-way based on the law, based on the criteria that the state gave, and just not have to do this whole testimony thing?
Yes, I think they could. I think, you know, they sometimes say that only a court can adjudicate and definitively declare that a road is an RS 2477 road. And that may be the case, that the court can say this is an RS 2477, but there are lots of other methods that the BLM or the federal government has to quiet title, to disclaim title, to recognize the state and the county's claim.
It would seem to me that if Salt Lake County could abandon their RS 2477 claims, that it would be equally true that the Bureau of Land Management or the federal government could abandon its Title V claims. It seems to me that that should be an equal...
To take them away.
That's...
Take it away, just limit access altogether. So some goofy administration in the future could say, we want to turn the whole place into primitive, you know, therefore you're not welcome out here.
What would that do to... If you were to shut off all the disputed roads in Kane County, the ones you're challenging, if they're just all to go away, what kind of impact would that have on your county?
I think the impact would be huge, not only from the standpoint of people that would, you know, have an expectation to be able to be out there, but what about the whole effort in terms of law enforcement, search and rescue, and all the rest of it that we need to have access to be able to manage ourselves in an effective way and fashion. So, like I said, it's bad faith all the way through.
And some of these roads, like I said, the only way to get to these areas are these roads. And I remember doing a deposition of a family in Grand County. They were getting a little older, and they have an adult son who's disabled, and they love to be out in the country. But they can't hike, they can't backpack into the backcountry. They can do it in a truck, they can do it on a four-wheeler, and so they love to be out there, but closing these roads to only backpackers is really limiting it to a very small percentage of people who love to be out in the country.
Okay, so I take a look at Kane County, I take a look at San Juan County, I look at the road system. I think even a backpacker would be cutting themselves short. It literally seems to me if they took the entire transportation system that's in dispute and closed it, it would actually bite the hand that's been so excited about having them maintain the control and manage access, because their access would be cut off too. I don't think there's a possible way that you could hike across Kane County from Johnson Canyon Road to Tickaboo in any season of the year and survive, is there?
No, I wouldn't try it.
Well, even if you're young and 25 and you know, backpack all the time, I don't see there are places. I don't see. I mean, if they had Red Rock Wilderness, I don't know how you'd ever even access all that land. I guess that doesn't matter. You just never know what was happening out there. So where do we go from here? I mean, the depositions obviously are very important, but do you think the other side is using this as a timing strategy, just to wait out until everybody who can make testimony dies off?
Well, it's hard to know why they're slow walking it or why it's taking so long. Commissioner Matson earlier I mentioned the bellwether process, and that's part of the litigation that's starting to proceed more quickly this year, where we're going to take about a dozen roads and starting focus in Kane County, and we'll be able to try some of the legal issues that are still in dispute or that are still unclear and be able to resolve those. I think that'll really help us to get moving along. We've been collecting all this testimony as evidence, but there's still a lot of legal issues that we're unsure about. Things like the scope of the road, how wide should a road be? Or what counts as public use? Is it, farmers and ranchers, do they count as public use? How many people do we have to testify to a road? And so we're going to focus on these 12 roads and get some decisions, get some adjudication on some of those roads, so that we can then apply those legal theories and that framework to all 12,000 roads.
If they only adjudicate 1 point per argument, though, it's still going to be a laboriously long, bankrupting, decades approach to solve the problem. Are we looking at saying, let's solve all of these issues at once?
I think we'll try to hit all the main legal issues that we're unsure about in this bellwether process. I don't think anybody wants to adjudicate 12,000 roads, but if we can solve some of the legal issues, if we can get answers to some of those questions, then perhaps we can sit down and say, okay, this road qualifies because we have the legal framework, and that's been clarified by the courts. And so that we can take these 12, take what we've learned in deciding those 12 and apply them to all of our other cases.
So if this were in a perfect world scenario and you got to a point where every time you made a court challenge, you won, right? I mean, there are some people who are gasping that I just said that, and they're falling off their chairs, and I'm sure they're already starting to write really nasty emails to me. But if you got to that point where you were in that situation, would you be able to just have them say, well, there's no way we can win, let's just not litigate it anymore, let's just sign an ROD, record of decision?
Yeah, or a disclaimer of interest, a recordable disclaimer of interest.
Sure.
There are different ways the federal government could kind of say, could recognize our claim or stop fighting it. There's certainly ways that they could do that.
So the ball's really in their court, isn't it? I mean, they have the power administratively to put an end to this just by changing their tactic, or is it still going to be forced into the courts?
Well, they've also got budget. It makes you wonder just how much are they interested in expending on the question, when I think it's so wrong, so.
Yeah, well, I can think of a half dozen other people I've talked to I could put right in that chair where you are, and they would say this is the most right thing to do, because counties shouldn't be trusted with having ownership of any roads. They will just abuse them.
Well, then I'd welcome them to come live in our county and learn more about it then.
And I think there's some misconception about the roads themselves. I think it's important to note that these are roads that have been there. They're not new roads. We're not cutting paths through wilderness or through undisturbed territory. And the other issue is that it's not that we own the land. We get a right-of-way, which means the state and the county gets to share a right-of-way that the public can use. But there are still limits on how that right-of-way is used. We can't, nor do we want to, turn every dirt road into a 2-lane highway. There are limits on how wide it can be, on how far you can go off the road, things like that. And so it's sometimes some people that don't like RS 2477 like to paint the picture that we're going to pave every road that's out there and turn every little cow trail into a 2-lane highway. That's simply not the case.
What do communities that are going to be affected by this, what do they need to be doing right now?
Well, I think stay informed on what the situation is, and make sure that your point of view and whatever it is that is of value to you is understood, and express those, pro or con, but you get more directly involved instead of just making this a media event, and we all end up looking at this as if we live along paved highways and the backcountry is off limits. I think we need to have more direct investment in that kind of a process by our local residents.
I think making your opinion known to your elected representatives is very important. And I think, I also mentioned the depositions that we're taking. We're always looking for new witnesses, people that were out on those roads prior to 1976. And so if people are interested in sharing their life experiences and their use of the roads, then that would be great to contact the state.
All right, let's take a time check on where we are, because the depositions have been going on for almost a decade, I think, haven't they?
Not quite that long, but they have been going on for a few years.
Okay, so how young can somebody be before their testimony doesn't count?
They have to be at least 60 years old when we take their deposition. And so it is important, because we're going back before 1976, we understand that that's the younger you get, the less likely you were out on those roads prior to 1976. But the way that the court has allowed us to take depositions is that we are allowed to take people who are 60 years or older.
Okay, and does the other side get to depose them at the same time?
They're present for the depositions. They can ask them questions and ask them about their use of the roads and those kind of things. But it's mostly the state that is taking charge of those depositions.
So I'm an 80-year-old woman. Oh, just because I can identify with being that these days. No, but I think I would like to help because I want to protect access to a place our families used, but I'm afraid of being deposed and having, bright lights and somebody saying, "Where were you on the night of the?" I mean, what is a deposition like?
That's a great question. It's a pretty informal process. It's not antagonistic. The federal government that's there and the environmental groups that are represented are not asking a lot of tough grilling questions. It's really a conversation between myself, for example, if I'm the attorney there, and the witness, to ask you questions of, do we go road by road, and we just want to get your life story. We want to learn why you were out on the roads. We want to learn, were you hunting? Were you fishing? Was this a favorite spot that you like to go because it has a great viewpoint? Was it something that you went to check your cattle, or was it, any of the reasons? And we just talk about why you were there, what you remember, how often you were on those roads, almost like an oral family history.
So some people might be afraid if they don't have really good recall that they could be convicted of lying to the federal government. I mean, that seems to be a pretty popular theme these days. Is that really a risk with this if they don't remember clearly?
We just want your best testimony, your best recollection. If we talk and you say, I don't remember a road, that's fine. We move on to the next one. And we just want to get your best understanding. We know we're talking about things that happened decades ago, and you are under oath, but we're just asking for your best recollection of what those roads meant to you, how you used them in your life.
Those areas are already under land management plans that protect the resources, protect the areas as such. So there's no real big chance for mischief to take place other than, why can't we have access? It's being taken care of in a very adequate land management process. So I fail to understand and see why we're messing around with this like we are.
Jim, what would happen to recreational access in your county if these roads were closed? Would it change the nature of how people recreate in your county?
Well, yes. In fact, I think access has been a major factor to that same question, and it's been increasing as we go along too. And we can take a look at our revenues that are collected on restaurant and on hotel taxes based on the people that come to visit our unique areas. So if all of a sudden the access is limited, what are we supposed to do? Do we go to the Grand Canyon instead? No, I think we need to visit and look at our own areas as such, so I think that'll be a big factor.
Gentlemen, thank you for taking the time to talk to us about this. It's a very good conversation. So bringing this to a personal point, when we come back from our break, we are going to talk to somebody that's been deeply involved in the RS-2477 process and what its impact potentially and literally means to him. Stay with us here on the County Seat.